In this video, we're going to talk about the concept of joint ownership of patent rights. Now, in a previous video, we talked about joint inventorship, where you have more than one inventor named as an inventor on a patent application or patent, and how easy it is for someone to qualify as a joint inventor. When you have joint inventors, you may also have joint ownership, because until all the inventors have assigned their patent rights to a single owner, each of those inventors is going to own their share of the patent rights, and therefore you have joint ownership. Joint ownership can also arise from contracts. For example, if an invention is created during the course of a research that's covered by a sponsored research agreement, that agreement could assign joint ownership rights to different entities. Joint ownership is seldom an ideal outcome for early stage tech companies. That's because either joint owner can do whatever they want with their patent rights. Each joint owner has the right to make, use, or sell the technology covered by the patent. Each joint owner has the right to assign their joint ownership of the patent rights to someone else. And each joint owner can freely license their rights under the jointly held patent to someone else. This means that neither joint owner can ever have exclusive rights to the marketplace covered by the patent application, or could ever transfer those exclusive rights to someone else. There's a couple other problems with joint ownership. We've already mentioned the fact that neither joint owner has exclusive rights. Also, each joint owner holds an entire undivided interest in the patent rights. Think of each joint owner as owning 100% of the patent rights. This may not align with the respective contributions of each joint owner to the patented technology. For example, one inventor may have just made a relatively minor contribution that's just reflected in one claim of the patent. Another inventor could have contributed to the entirety of all the other claims in the patent. Nonetheless, they will each be joint owners, and each have an undivided interest, even though their relative contributions don't align with that equal sharing of rights in the patent. This often is not a desired outcome and would need to be changed through a contract. Another problem with joint ownership is that the laws in different countries differ with respect to joint ownership. For example, in the United States, as we discussed, either joint owner can freely license their rights to whoever they want. But in other countries, it takes the permission of all joint owners in order for one joint owner to license their rights. Japan is an example of one of these countries. So with joint ownership, you could have a strange outcome where someone could try to license worldwide rights to a patent, and that license may not be enforceable in Japan, whereas it may be enforceable in the United States. So because joint ownership is seldom the desired outcome for an early stage tech company, if you have multiple contributors to your patented technology or to the technology for which you're pursuing patent protection, it's important to make sure that each of those contributors that may potentially be an inventor and therefore potentially have joint ownership rights has assigned in a written IP assignment agreement their rights to your startup company.